For a long time, political party coalitions in Kenya relied on coalition agreements to curb betrayal and deceit among political participants. However, occurrences of coalition agreement breaches during the August 9, 2022 elections appear to have compromised the value of coalition agreements, as numerous parties sought to shift allegiances. NTV's political affairs reporter Vincent Odur looks at the place of coalition agreements in law.
Order, honorable members.
The recently concluded battle over who between President William Ruto's Kenya Kwanza and Raila Odinga's Azimio la Umoja One Kenya is the majority in the National Assembly put the worth of coalition agreements on the spot. Majority of coalition agreements in the world are done informally, but in Kenya it was formalized into the Political Parties Act, requiring parties to deposit those agreements with the Registrar of Political Parties. Lawyer Charles Kanjama says such agreements matter in law.
Any agreement which is recognizable in law, and that includes a coalition agreement, is enforceable. It becomes binding and enforceable. So if somebody breaches or violates such an agreement, you can take them to court. Among
the 26 political parties that had signed the Azimio coalition agreement before the August 9, 2022 election, 4 political parties after the election jumped ship and joined the Kenya Kwanza alliance in a new post-election agreement. This is despite the Azimio coalition agreement requiring them to not leave the coalition for at least 3 months post-election. The move boosted Kenya Kwanza numbers on the floor of the House, which informed the ruling made by the Speaker of the House on who has majority.
You cannot be forced to remain in a party or even in a coalition against your will. But so far, the courts have not struck down any coalition agreement on the basis of infringing on political rights. So this is an issue that we may determine in the coming days.
Will Azimio sue the parties for breaching its agreement?
Azimio la Umoja can actually go to court and sue these parties that have left the coalition, because by their leaving they have made the Azimio coalition lose certain opportunities that otherwise it had. The question of whether that breach or violation has resulted in an injury that the court is going to give you compensation or another kind of remedy is a new issue. It's a novel area of law, because typically political agreements are not agreements for which you can get monetary compensation.
Previous coalitions like NAC of 2002 were unable to hold because they were based on a gentleman's agreement, which was not faithfully executed by the parties after election victory. These contributed to the emergence of legal coalition agreements, but Kanjama argues such agreements have not been able to deal with political betrayal and deceit in Kenya.
The first weakness is that we now have 2 kinds of coalition agreements. The traditional coalitions, and then what are being called now the political party coalition, which, as everyone has admitted, is a mongrel, because it's on one side a political party, on the other side it's a coalition agreement, and it is causing confusion. Even when you look at the Political Parties Act, you're not allowed to belong to 2 parties. But if you're in a political party coalition, you're actually in 2 parties. So this has caused an area of confusion that needs to be clarified. So there'll need to be greater analysis of what kind of provisions a coalition agreement can have or not have.
The latest president in parliament threatens to permanently deny the opposition majority, since the one who wins the presidency will be able to poach members of parliament to his side to make his coalition the majority. Vincent Odur, NTV.